I'm sorry, Josephine Marquin.
Judge, we are on the docket today.
Whoa, okay, we're starting off with high stakes. The plea deadline is over. Translation? No more deals unless there's a really good reason. At this point, it's like walking a legal tightrope without a net. Would you roll the dice on a court trial if the plea window just slammed shut?
We'll confer with the state in a moment, but I knew you were going to start picking a jury and there was an urgent issue. They've agreed. We've asked you to sign an order that allows pretrial to loosen her leg monitor a bit. Her doctor submitted a letter to pretrial saying that it's causing her swelling and pain. And pretrial told me they would not loosen it without your order. So the state has graciously signed off, and I just wanted to get that done.
Who is the pretrial officer?
Her name is
Valdez.
Priscilla Valdez.
And a judge,
No, talk,
okay.
just me. I'll talk for you.
Of that.
All right, just give me 1 second.
Just
All right, well, I understand that, but
And you say Valdez?
Valdez. I have her
Priscilla.
email. If you want me to forward her email to Norma, I can do that, Judge.
Yeah, let me see her email.
Okay.
Do you have any objection to the court sending her email, letting her know that the monitor is to be loosened?
I have no objection.
Okay.
Priscilla, P-R-I.
Oh, just 1 second. It's probably best that I just see it.
It's, I understand what you're saying.
Ain't no problem.
This isn't just courtroom logistics, it's literally pain management. The defendant's ankle monitor is causing physical harm, and they're jumping through judicial hoops just to get it loosened. Here's a real question. Should pretrial conditions prioritize health more? Or is the system too rigid to adapt?
And I apologize, I left my jacket in the 379th, but when they said you were about to pick a jury, I just ran over here.
Oh, no problem. Okay. Wait a minute.
It's not the first time I've had issue with this particular pretrial on a case.
RIS.
And if need be, I'll set the remainders of bond motion for a hearing because the state couldn't agree to just completely removing it, of course. But I just
Okay.
wanted to make sure it got loosened because she's been in pain for a while.
All right, thank you.
And I'll come back and confirm.
All right, thank you.
Thank you, Judge. You still that. Thank you so much. I'll be back to confirm. I believe today was our plea deadline. We decided the discovery acknowledgement. She's rejected the plea, so we'll need to set it for trial.
All right. So do you want a jury trial or a bench trial? If you come to me for a bench trial, if the state proves its case beyond a reasonable doubt, I'm going to find you guilty. If they don't,
I'm not going for excuse me, I'm not going for a jury trial. I just need time because I have all my stuff in the storage yonder. And I haven't taken nothing else because of the monitor, and I understand.
no, so here's the thing. Today is your plea deadline date. So these are your only choices. Either you're entering into an agreement with the state today, or either this is being set for a jury trial or a bench trial. A jury trial, what happens is 12 people sit in the box. The state presents their evidence. Either a jury, if they can come to an agreement, they'll either find you guilty or not guilty.
This is Courtroom Clarity 101. The judge is breaking it down what a bench trial means, what a jury does, and how beyond a reasonable doubt isn't just a phrase. It's the cornerstone of justice. If you were the defendant here, would you choose 12 strangers or one judge? Comment below.
Or say we can't reach an agreement. If you decide to do a bench trial, that means that I will hear it or another judge will hear it. The state will again call their witnesses. If I believe their witnesses and find them to be credible, and I believe that they prove their case beyond a reasonable doubt, I'm going to find you guilty. If I don't think they've proven their case beyond a reasonable doubt, I'm going to find you not guilty. So your choices are for today are, do you have an agreement with the state? If
No.
not, then it's either jury trial or bench trial.
I thought I had until January.
No,
No?
no,
Well, I don't know yet. I gotta talk to my son.
no. How old are you?
I'm 65.
All right,
No,
don't put that,
65.
here's the thing, don't put that pressure on your son. It's your choice. So either you're going to reach an agreement today or either you're going to jury trial.
I guess I'll do the jury trial.
All right, Ms. Ferguson, it appears that this is a case that shouldn't last long. It's a drug case. Excluding jury selection, it'll probably be 2 days. So your plea deadline date has expired. The court will not consider any plea bargain agreements with that good cause. Otherwise, you have to plea open to the court. Do you understand?
That's fine.
What date? All right, your jury trial date is going to be September 9th. Once you sign the reset form, you're excused. Just have a seat and your attorney will bring the reset form to you.
Okay.
Welcome. And counsel, it shows that the recipient read that email, so everything should be fine. You're welcome. You're welcome. You have a subpoena, which you told me you have a subpoena. What's going to end up happening is the state, they can file legal documents to have you attached. What does attachment mean? That means that an officer or some member of law enforcement will go pick you up wherever you may be and bring you in to testify. Do you understand? So they're going to call you, let you know where you need to be and when you need to be for your testimony, and you need to make sure you're here. All right. So do you have any intention of not appearing? All right. Is there any question you have for me about subpoenas and what they mean? All right. So you've been subpoenaed as a witness. That means that you have to appear. That's a legal document, and there are consequences for not appearing when you've received service. Do you understand? All right. Thank you. Good morning.
Good morning.
All right, the court is calling 2017 CR 3456W, State versus Katrina Goodwin. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Todd Conrad, Miss Goodman.
And are you Miss Goodwin?
Yes.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Katrina Goodwin who was placed on deferred adjudication in 2017 CR 3456W for the offense of theft of property less than $200,000 on May 15, 2017 for a period of 5 years and extended for a total of 5 years? Is that you?
Yes, Judge, that was me.
All right, state.
Yes, Judge. State is alleging that violation of condition number 2 on or about the 6th day of January 2025 in Bexar County, Texas, the defendant, Katrina Goodwin, did then and there illegally use a controlled substance, namely amphetamines, in violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
The state will waive and abandon the remaining violation, Your Honor.
No objection, Your Honor.
Just one moment. I'm trying to find the indictment. Here we go. All right, I think the judgment needs to be corrected. We can go off the record. The judgment needs to be corrected. The judgment puts this as a second-degree felony, but she pled to a third-degree felony. So just one moment. This was before my time. All right, Adriana, the judgment on this needs to be changed to reflect that it's a third-degree felony. All right, we are back on the record. So you entered a plea of true to violation of condition number 2. Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Judge.
Yes.
That agreement is to continue probationer on probation, but the state is recommending, in line with the probation's recommendation, a 1-year extension.
Oof, that's the moment it all turns. Years of probation done. This is more than a legal decision. It's a judgment call. The judge clearly believes the system's efforts weren't enough. Do you think that's fair? Or should addiction be treated differently when it comes to revocation?
Weekly reporting and weekly UAs for the first 30 days.
All right, thank you.
Yes, Judge.
All right, so Ms. Goodwin, I don't think you're a good candidate for probation. And let me explain to you why. This is not your first time with a motion to revoke. It doesn't appear that there's anything else that can be done to help you. I understand that drug addiction is very difficult to conquer and you have to stay vigilant. But when people give you the tools that you need and you just don't use them, that's a problem. So I don't think you are a good candidate for probation. And I'm not going to continue you on probation. So I'm going to grant the motion, find you guilty, and revoke. Counsel, did you want to speak to years? Because
Yeah.
she's been on probation since 2017.
Correct. She has completed the successfully Take Peach program.
Mhm.
And judge has also done the 90-day jail sanction. So she has some back time.
For years, restitution owed. The weight of consequence hits like a gavel. But here's the kicker. This isn't just punishment, it's a reset. The court offers one last door, therapeutic community, but she has to ask for it. Redemption in the justice system? It's there, but you've got to knock.
So we're asking for the minimum 2 years because she was hoping to get, of course, continued with the objective of paying the rest of the restitution. That's why they're asking for an extension of a year.
Mhm.
But without that, then we would ask for the minimum 2 years.
And probation, what's the amount of restitution?
Outstanding amount of restitution at this time is $6,977.11.
And who does that restitution go to? All right, the court, as previously stated, is going to grant the motion, revoke, find you guilty, give you credit for any time served, credit for any time in any successful completion of inpatient treatment. There's to be restitution of $6,977.11 to U-Haul. The therapeutic community, the court will sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? And did you sign it?
Yes,
You do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
yes, ma'am, I do.
All right, we can go off the record. Here's the thing. We can only do so much, right? The therapeutic community is a good program, but you're going to have to request it. I have no jurisdiction to force them to place you in the program. Once you're released from prison, if you can't find a place that can help with your drug addictions, if I'm still here, you can come back here and I'll find a place for you, okay? All right, good luck to you.
Thank you.
You're welcome.
Every excuse.
Yes.